The broadcast is now starting. All attendees are in listen-only mode.
Hello, everybody. I want to thank you for attending the session on top 5 library policies, plus a couple more. We have about an hour to go through quite a bit of material, so I'm hoping you guys can bear with me. If there's any questions, I'm going to ask that you send me an email, and my email is right here on the front page, so if you could send me an email after this session, I can handle it that way. I'm not sure that we'll have time to do a lot of questions during the presentation. Sorry about that, a little technical difficulty. Oh, there we go. I always have 1 or 2 technical problems. So, why have policies? Policies regulate behavior of both patrons and staff. Policies govern the use of property and solidify common procedures. So this session will focus on policies that apply to the public and governance of the libraries. Other policies, such as library policies, are important but will not be addressed here. So I don't want to disregard the need to have employment policies. Employment policies are very important, but that would be covered by an entirely different presentation. I want to explain why you need to have policies. I have a lot of clients that ask, why do we need so many policies? Why do policies have to be so long? Sometimes they feel that it doesn't indicate that they're patron friendly by having lots of rules and regulations, but there is a reason why you have to have written policies and why they have to be the way that they are. And so I want to spend a couple minutes discussing that so you can understand the basis for that opinion. First of all, the library is a governmental body, and you are governing and regulating public property. So the question always is posed as to what level of regulation can you make for property that is open to the public? Like libraries. Libraries are generally open to the public. And how far can you regulate the use and who can come in and who can have access? The nature of the government's activity will determine the extent of the activity that may be regulated. The courts have stated that the First Amendment does not guarantee access to property simply because it is owned or controlled by the government. So just because it's public property doesn't mean that an individual has complete and total access to the public property, and this would include public libraries. When you talk about public property and the fact that you are a governmental body, we have to be concerned about First Amendment issues. So what does the First Amendment guarantee? The First Amendment guarantees a couple things. The most common First Amendment right that libraries are used to dealing with is the right of access to materials and what you are reading. You know, the censorship. Can the library censor what people are reading, looking at on the internet, and so forth? So those are those First Amendment rights. And we're going to talk about this a little bit more when we talk about the internet use policy. But when we talk about policies about patron behavior, for example, and policies that will end in and result in the possible suspension of privileges, the other First Amendment right we have to be concerned about is the First Amendment right to receive information. There is a separate First Amendment right of access to a public library. It includes some level of access. So each time a patron is banned or denied access, it impacts the First Amendment right. This is true if you ban someone for 6 months. It is the same First Amendment implications if you ban someone for the last hour at the end of your day. So that's why we have to be very careful on how this is done and make sure that it is done in conformance with the law. when you talk about libraries, and I'm going to back up a minute because I want to discuss the different types of what we call public forums. And public forums is the legal analysis that we use in order to determine what level of access someone has and what level of regulation a public body can do. A patron says, "This is a public building. I paid for it with my taxes. You can't tell me what to do." And is that patron correct? No. A library is a limited public forum. Now, the different types of public forum there's a traditional public forum, a limited public forum, and a non-public forum. A traditional public forum, which a library is not, but possibly the outside of your building and the grounds could be, depending on what your setting is. But typically, a traditional public forum are things or places where, over the course of our history have been traditionally presented as places of public discourse. For example, a public park, or the steps of City Hall, or a sidewalk. Those are going to be traditional public forums, and it's going to be very difficult for a public entity to regulate the use of those spaces. It's more difficult. A non-public forum, again, keep in mind that library is a limited public forum, and I'm going to get into what that means, but a non-public forum is a place that has not been held out at all for public discourse or public discussion. So if I go to the FBI building in Washington, D.C. and walk in and say, "Hey, this is a public building," I'm just going to wander around, and that's a non-public forum. It hasn't been open for the public. It's for a place clearly of doing business. So I certainly think that that is there's a lot. It's a lot easier to regulate and prohibit access to those non-public forums. A limited public forum is really somewhere in the middle. A limited public forum is not open to the public at large, like a park would be, or the steps of City Hall or a sidewalk, but maybe open to a specific class of people for the discussion of a certain subject matter. And this was really fleshed out in the Kramer versus Bureau of Police case. This is a important case in library patron behavior, because what it did was it set the parameters for what patron behavior policies can say. In Kramer, and there's two cases, and we'll briefly discuss both of them, but in Kramer, it involved a homeless individual who came in and used the library. And the library kicked this particular individual out because he was sleeping at times, he wasn't using library materials, he had an odor, using the washroom for, bathing, those types of things. And the court said that the library rules in Kramer made it clear that the library was only open for reading, studying, and using library materials. And the library has not opened its doors to the exercise of all First Amendment activities. And so this really set the stage for libraries being able to regulate and keep within the mission of the library. Basically, the library rules and regulations that you can adopt really are intended for the patron to use the library for reading, studying, using library materials, and not for other types of purposes. And we'll get to how you would specifically state that in the library policy. So what does that mean? It means the library may promulgate and enforce reasonable regulations governing the use of its facilities. For example, a rule that requires patrons to use, requires the patrons using the facility to be using library materials while at the facility was reasonable. The library need not to be used for a lounge or a shelter. The library could also prohibit disruptive behavior, and the court said prohibiting disruptive behavior is perhaps the clearest and most direct way to achieve maximum library use. So things like keeping your voices low, not taking calls in the library, not sleeping in the library, those are things that all are conducive to good use of the library. So there's two types of policies or two types of regulations that I want to talk about. And one of them is a time, place, and manner regulation, and the other is a substantive regulation. And the goal for the library would be to keep regulations into this time, place, and manner category, because time, place, and manner regulations are permitted if they're narrowly tailored to serve a significant governmental interest and leave ample channels of communication over. This is a lower standard of review that the courts would analyze if someone had or versus a substantive regulation. Okay, for example, and I'm going to give you an example of how this would play out in a library setting. There's been cases over the years about religious organizations using library meeting rooms for worship services, okay? If the library enacted a rule that said you couldn't have religious worship services in the library meeting rooms, that would be a substantive regulation. You are not regulating the use of the building, you are regulating who is using the building and what message they are conveying. You are addressing the substance of their communication. That is going to be a very hard standard of review. If the library were sued over that and the courts looked at that, you'd have to have very good reasons, and they'd have to be extremely compelling in order to uphold that regulation. Now, a time, place, and manner regulation that would be easier to uphold would be a regulation, for example, that says you can only use the meeting room 2 times a month. Now, that may impact a religious worship service that has been held every Sunday, but if you apply that time, place, and manner regulation evenly to all groups, regardless of their message, it's going to be more likely upheld than a provision that significantly targets a specific use. So check out your policies. One of the tips I give is look at your policies that you have in place today. If you see, commonly I see policies that do address and prohibit religious uses, political uses, other similar types of uses. If you have policies in place that address that specifically, I would have those reviewed, because those are going to be high standards to meet. And then one thing, I wanted to go back. In Crimer, there was also a appeal procedure. So the importance of any policy where you're going to limit access to the library, it's any policy that would allow the library to prohibit uses or suspend a patron privileges should have an appeal procedure. And that appeal procedure should be one that is not made to the person who made the initial decision. For example, if the library director is the person that makes the decisions on suspensions, the appeal should not be made again to the library director. That would be an exercise in futility. My recommendation strongly is to make the appeal to the library board itself. So we mentioned that Crimer case, and the court did uphold those. The court did uphold the decision of the library to ban that particular patron. And I contrast this with this Armstrong versus District of Columbia case, because in this case, it was almost the same set of facts. It was a homeless man barred from the library, but the library prohibited what they called, quote unquote, objectionable appearance. The court found that that was too vague and too subjective. What's objectionable to one person may not be objectionable to the other. In Crimer, what the standard was is they said that anyone who created a nuisance could be banned from the library. And a nuisance is actually a more objective standard. It has a legal meaning, and so it was easier to enforce that versus objectionable. So vagueness is an issue with library policies. Being objective will be easier to enforce. Also with that Armstrong case, there was no ability for them to have an appeal. There was no appeal procedure. So that was something that was missing, and in the court, in that particular case, the court did not uphold the decision. I want to talk again a minute about Brinkmeyer versus City of Freeport. This is also one that involved the application of a library policy. A library employee was approached outside the library by a man who handed her a quote unquote harassing letter. The man was removed from the library. In this case, there was no harassment policy at the library. There was what they specifically referred to as an unwritten rule that the library prohibits harassing or intimidating patrons or employees. So that was a situation in which you have to have a specific policy in place, and it has to be in writing. And the court again found harassing was too vague. And I'm going to provide a specific example of language of harassing where I think there's a contrast between just using the term harassing and something that's a little bit more objective. Again, the case, there was no geographical limits in this particular case in Brinkmeyer. The court didn't limit its application to the library or the library property. It sort of went without saying, but the policy didn't say that, and so the court found that was troubling because it happened outside, and the court felt like, well, what if it happened in the local grocery store? Could the library still enforce it? Again, it was one of those things that it has to be specific. And it has to be in writing. As a result, the court did not uphold that particular suspension. 9S versus Board of Trustees of the Columbus Metropolitan Library. Again, this is a case where the patron believed that the rules did not apply to them. I don't want to spend too much time on this case, but the person was removed from the library for failing to wear shoes. There was a policy that required shoes. Patron argued that there was going barefoot was symbolic speech and he was entitled to First Amendment protection. The court or the library enacted the rule for health and safety reasons. And I do put this in there because it's sort of gross, but it does depict how far the library had to go in order to uphold its provision for going barefoot. It had to do a report as to what was actually found on the library floors and that the library is protecting this particular patron from. The courts found the rule was reasonable, protected the patron, but also protected the library from litigation expenses that may result in the injuries to barefoot patrons. So here you can see this brings up an important point. Even if you have time, place, and manner restrictions, for example, going barefoot or wearing a shirt, you may get patrons who argue that their particular beliefs, First Amendment, religious, whatever, come into play when making these rules. And so that's a situation, if you're faced with that, where you should seek some legal counsel on that particular enforcement issue. So I want to talk about patron behavior policies first. And what we've just done is set the legal framework for why you have to have it in writing and why patron behavior policies are, I think, your top #1 important policy to have in place. When I first started doing working with libraries, my patron behavior policies were probably 2 or 3 pages. Now there's 7, because patrons keep doing new and interesting things in libraries. And as you remember before, it has to be in writing. The elements to a good patron behavior policy, it has to be objective, time, place, and manner, has to be in writing, and the possibility of the appeal. So every time a patron does something that is sort of unthinkable at the time you draft the policy, you have to add it to the policy to make sure you can enforce that particular policy. And I'll give you an example when we go through this. Remember to limit the conduct to the library building or library grounds or both. So typically in the beginning of a patron behavior policy, we will say that, you know, the rule applies to the library building and on library grounds unless otherwise specified. A good example would be, for example, smoking. You would have a no smoking inside the library building policy, but you may allow it on certain places or outside in the library grounds. So you want to make sure you distinguish that. You clearly address specific conduct that will result in the suspension of library privileges. And I want to go through just a couple of behaviors that we specifically address in a policy. One is violations of the law. So committing or attempting to commit an activity in violation of federal, state, or local law, ordinance, or regulation, okay? Assault, you know, if there's a fist fight in the library, if someone's stealing that, removing material is prohibited. Now, what's interesting to this is that, this is not a legal, you know, criminal standard. So if you believe as a library that someone tried to steal something from the library, even if in a court of law they couldn't prove it, you don't have to wait for the court case to, you know, go through. If you believe it, if you think there's a violation of the law, this is something you can enforce on your own as a library. Vice versa, if someone is actually found to have violated the law in your library, you still have to go through the library's own behavior process, sending them a notice that they've been prohibited. The criminal action itself is not going to limit them from coming back to the library. That's something that's an extra step that the library has to take into account. Send them the letter, send them the notice of their suspension. Engaging in proper library activities. This is the one that was upheld by the Crimer Court, and we talked about that, making sure that when people are in the library, they're using the library for library purposes. So patrons shall be engaged in activities associated with the use of the library while in the building or on library property. Patrons not engaged in reading, studying, writing, participating in scheduled library programs, or using library materials shall be required to leave the building and shall not remain on the library property. This one is used a lot it is used with homeless individuals. It is used with, kids or other individuals who come to the library not intending to use the library, but really intending to use it as a lounge or a place to be, and is causing disruptions. So this is something that's been upheld by the courts, and we recommend it in every policy. This is the restrooms and the harassment is the ones I feel like I still have to keep adding to because of new and different ways people have found to get around these. So misuse of the restrooms, including laundering, shaving, hair cutting, trimming, bathing, and sexual activity is prohibited. It used to just say don't take books into the restrooms or don't misuse the restrooms, but now we have to prohibit specific activity in that. Again, harassment. If you go back to the prior court case we talked about where they specifically said you cannot harass people, this is what we believe is a more objective approach to an anti-harassment. So staring, photographing, video recording. We just added video recording because of a behavior of one patron who would just stand there with their phone and video record employees and make them very nervous. Following, stalking, harassing, arguing with, threatening, or behaving in a manner. So those are set the stage for the types of behaviors, but here's where the objective part comes in, which can reasonably be expected to disturb library users or staff while such staff or patrons are in the library or on library property. Again, we learned our lesson from that other case where the court said you had to make sure it related to library property and or that interferes with the patron's use of the library or the ability of the staff person to do his or her job. So if you have a person who is constantly even just talking to or, following, one of your employees who's shelving books around, so the point where, and we've had this where people, feel uncomfortable even being out in the library when this particular patron's in the library. This is a provision that you can use to enforce and prevent that type of behavior. Interference with staff. This one can also be used, and it's a slight variation of the patron policy, but it's a little bit less, it doesn't show you have to follow them or stalk them or harass them, but basically patrons may not interfere with the performance of their duties. This includes engaging in conversational behavior that monopolizes or forces attention of the staff for inappropriate period of time, inappropriate personal comments, sexual advances, and physical and or verbal harassment. Unfortunately, this is a very used provision in a lot of our libraries. Library staff, because you're dealing with the public, are often subjected to, lonely people who want to come and talk to you at the library. You're subjected to people who make inappropriate personal comments because you are sitting there at the desk and they feel like they can approach you in that way. That's not acceptable, obviously, and this is a provision that the library can use in order to prevent that type of behavior. Staff areas, again, this is one of those provisions that we have specifically added based on the behavior of patrons who did not feel that a staff only sign meant staff only. That was just a suggestion, not a directive. So that's why we have now included staff areas, although it seems like we're stating the obvious. We found that there's people who have challenged us on that basis, and if it has to be, again, has to be in the written policy in order to be enforced. Library phones and staff computers are for staff use only. This one is actually becoming a lot more obsolete with, you know, everyone has a smartphone these days, it seems like, and many people have their own computers. But again, we want to make sure that patrons aren't infringing on staff areas. This is one, tables or structures on library property. We want to make sure that this one is, if you decide to include it in your patron behavior policy, that it's a standalone provision and not specifically related to where it comes up a lot is when individuals are wanting to use the library for petitioning or for political issues. They want to set up a table so they can gather signatures. You want to make sure that that tables and structures on libraries are permitted generally and not just when those activities are being conducted, because again, if we go back to the earlier slides, this provision is more a time, place, and manner provision. We're just saying no tables. I don't care if you're the Girl Scouts or the Boy Scouts selling popcorn or the local nonprofit, you can't have a table. But if you put this provision in the section that prohibited, you know, that dealt with petitioning, for example, then it would be likely to be more viewed as a substantive. The regulation is based on the substance of the speech, which is political speech. So that's why you have to be careful about where you place these provisions in your policies. Again, loud noise, I think, you know, we talk about trying to be objective, producing or allowing any loud or disturbing noise that would interfere with the use of the library or which could be reasonably expected to disturb other persons. So it's more of an objective. You can't just say it's loud, because loud to, yeah, I've got kids. Loud to me is different than loud to them. So in the context of a library, can it be reasonably considered to disturb other persons using the library? Body odor. Again, this is one that we've seen an increasing amount of use. Just say offensive body odor would be, I think, hard to enforce. And that's why we add that causes a nuisance. And that was, again, one of the provisions that was upheld by that crime record. Again, unauthorized use. Plaintiffs must leave the library promptly at closing time and may not be in the library when it is not open to the public. Further, any patron whose privileges to use the library have been denied may not enter the library. We actually had to add that because we had a banned patron who kept coming back. And so we wanted to be able to add specific we wanted to add to the suspension period by having a different provision that he was violating. Again, so this is the reason that was added to that. And as patrons become more bold, you're going to see more of these types of uses. So, and I just put a list here of common issues that are addressed in patron behavior policies. I didn't have time to go through all of these, but again, they're bullet points of things that your library should consider when adopting or looking at your patron behavior policies. Meeting room policies. Again, these are going to be very similar to your patron behavior policies. Time, place, and manner restrictions should apply. Again, things that should be careful about making substantive policies against particular points of view. What the court does allow is for you to limit the use to the same mission of the library: educational, cultural, civic, informal, and similar uses. If you want to do that, you should specifically do that in your policy. Many libraries, though, are not doing that anymore. They are using meeting rooms. They have meeting rooms with kitchens. They're allowing nonprofits to come in. They're allowing for-profits to come in. They're allowing birthday parties. So you want to be really clear in your meeting room policy what uses are allowed, and then consult with your lawyer on how those different uses may affect the library's ability to enforce. So think about the use and not who is using the meeting rooms. And I give a couple examples here. So you cannot deny the use of meeting rooms simply because the organization is religious or political. Many nonprofits have political leanings. A recent court case suggests there may be problems with prohibiting religious worship service. I put this in here particularly because there was a California court that a while ago upheld the library's right to prohibit religious worship service. That caused a number of libraries throughout the country to amend their meeting room policies to prohibit religious worship service. it, it, the court then that was not upheld on appeal. So, and then there was a particular nonprofit group that went and targeted all the libraries that had this in their policy and threatened to sue them. So if you still have it in your policy, this is something that should come out or should be evaluated as soon as possible. So, and I give you a couple examples. Think of the uses. The New Day Church wants to use the meeting room for a Bible study. The No New Taxes group wants to use the meeting room for a constitutional law seminar, and the Girl Scouts wants to use the room for a book club. Okay, think about those uses and who those people are. Now, the New Day Church wants to use the meeting room for a private wedding reception. The No New Taxes group wants to use the meeting room to host a fundraiser, and the Girl Scouts wants to use the meeting room to sell Girl Scout cookies. Okay. So what's the difference? And I'm going to go back to the first slide. These are uses that are typically conducive to the library. For example, if you allow a book club to use the meeting room for the discussion of 50 Shades of Grey, you should allow people to come in to have a discussion about the Bible. No New Taxes, again, if they're doing a seminar, an informational seminar, it shouldn't matter that they're an anti-tax group if you allow other people to use the room for seminars. Similarly, the book club example for the Girl Scouts. Here, if they want to use it for a private wedding reception and you don't allow private wedding receptions in your library, you don't have to allow a church to do that. Again, it's a time, place, and manner. Similarly, the hosting fundraisers. Fundraisers are typically prohibited in library meeting rooms, and it shouldn't matter who the fundraiser is for, what the use is, if the fundraiser itself is prohibited. Again, commercial sales is the same thing. So in meeting room policies, you should limit use on the distribution of material. You don't want to make sure they can't leave material at the library or pin stuff up. Can they bring in food? What are the responsibilities for setup and cleanup? And is the library going to charge fees? These are all issues that should be addressed in any meeting room policy and apply evenly to anybody who's using it. They also should specifically address the patron behavior policy. Typically in the meeting room policy, we say, we do make a point of saying that the patron behavior policy and all other library policies will apply in the meeting rooms, because you don't want them to think it's a place of refuge where they can all of a sudden play loud music in the meeting room because they're, having a party in there. You want to make sure that if it's loud and it violates the library patron behavior policy, that it would also be prohibited in the meeting room. Again, because you are addressing, because you are potentially limiting the use or denying an application for a meeting room use, it should have a violation and appeals policy so that that person can take their appeal to the library board if they disagree with anything that the library staff has done with respect to enforcement. Again, make sure it's uniformly enforced and not used in a manner that violates Michigan law, such as the Michigan Campaign Finance Act. And we're real careful when we do this because we want to make sure that this comes up a lot. Let's say that you're going to be asked by your friends of the library group. Say your friends of your library group are also going to be your ballot question committee and are going to help the library with promoting a library ballot proposal. And let's say your meeting room policy allows these types of groups to have meetings in your policy that it's open and they follow your policy, and so that the vote yes committee is using your meeting room. It would be a violation of Michigan law and the Campaign Finance Act if you denied like a vote no group to use the meeting room in a similar way. So you can't give access to certain groups and deny access to substantially similar groups. It would be a violation of the Michigan Campaign Finance Act with respect to election-related issues. Even if neutral policies are applied only to certain groups, then there could be a violation. So again, let's say that the library is trying to promote its election and there's an anti-tax group that wants to meet in the library, and if the library allows the vote yes people to rent the room 4 times a month, and the rule in the policy is you can only rent it 2 times a month, and they enforce that policy against the vote no group, then you're going to have a problem. And the same, we see this a lot too with churches holding meeting rooms. So make sure that you uniformly enforce the policies so that the library cannot be accused of taking a neutral policy and applying it only against a religious organization or a political organization or a group of people that you may not like their message, because then it may turn into a higher standard review and may be more difficult to uphold. Internet use policy. Again, these are, we're doing top 5, and I think the meeting room, internet use, and patron are by far the most important policies, and that's because they're the ones that intersect with the patron's use of the library most often, and they're frankly the ones that deal with the most problematic behavior in the library. The use of the internet is one of those areas that we see a lot of, frankly, patron problems with. And so we want to make sure that the use policies are drafted well, have appeal procedures, and can be used in order to promote a good library atmosphere. So one of the key components of an internet use policy is the compliance with either PA 212 or SIPA if applicable. Now, all Michigan libraries are required to comply with PA 212. Not all libraries are required to comply with SIPA. SIPA only applies if you are receiving certain money that is tied to the requirements of SIPA. If anyone has questions about that, those we can talk about whether that's applicable to your particular library, but it's certain E-rate, for example, money is attached to requiring SIPA requirements. I don't deal with it that heavily in this program because of the time and because a lot of libraries have been foregoing that money because of the SIPA requirements. So please send me an email afterwards if you would like more information. But under PA 212, the Act applies if a library offers the use of the internet or a computer program, computer network, or computer system to the public. I highlight it specifically like this because I think there was some misunderstanding or misinformation years ago about the internet. The way I read this, and this is my personal opinion, and so you should talk to your lawyer if you have a disagreement on this or you would like a different interpretation, but I believe this applies to all wireless access to the library. So if you have wireless access, there's a number of libraries that I've come across that have that filter, for example, their hardware, their desktop computers, but don't filter the wireless. And I believe that the compliance must occur in both wireless and in your actual computer terminals. If PA 212 applies, the governing body of the library shall adopt and enforce a policy that restricts access to minors by providing them the use of the computer network. And there are 2 ways to do that. One involves filtering. So if you are a filtering library, you have to make available to individuals of any age 1 or more terminals that are restricted from receiving a obscene material or sexually explicit material that is harmful to minors. I've put the definitions in the PowerPoint here, and we'll be sending you a copy of the PowerPoint so you'll have that, because those are actually specifically defined under Michigan law. But you also have to reserve to individuals 18 years of age or older, or minors who are accompanied by their parent, 1 or more terminals that are not restricted. So in Michigan, under Michigan law, you have to have at least one unfiltered computer to allow individuals 18 years of age or older or who are accompanied by an adult. And as a side note, I typically recommend that the policy talk about what accompanied means, and that the safest way is to define accompanied to mean that the parent has to be sitting at the terminal with that particular individual. The second option is by utilizing a system or method that is designed to prevent material or minor from viewing obscene matter or sexually explicit matter that's harmful to minors. So privacy screens, staff monitoring, adult-only labs are examples of ways that libraries have done this. So if you are a filtering library, you have to leave one unfiltered, but there's other ways to comply if you don't. I'm not going to spend too much time on these terms because they are legal terms that are specifically defined in Michigan law, but harmful to minors means sexually explicit matter that meets all of these standards, okay? It's very, I will say that it's very hard to give concrete examples because, again, it appeals to the prurient interests of minors as determined by contemporary local community standards. So you have to talk about what those interests are and what the local standards are, and it's very hard to, it's sort of clear as mud on what this means. So we've been kind of wading through it, but again, the policy should specifically address things that are harmful to minor, and it may take interpretation when you are dealing with a particular complaint as to whether it is or is not a violation of Michigan law. But again, here's here's the definitions that we were talking about, and I want to talk about the second definition because I think it's really interesting the way that this is right out of Michigan law. In determining whether sexually explicit material appeals, you have to take the average 17-year-old minor's position into account. And I just find that fascinating that the law would, this is exactly what the law would say. So without taking too much time, it should address harmful to minors, but you might have to get specific legal help in determining whether a particular use of your internet or computers is a violation of Michigan law. SIPA is the Children's Internet Protection Act. Again, this is receipt of certain federal funding under the LSTA or E-rate. And it applies only to libraries that receive those grants. Now, under SIPA, all libraries must be filtered, even staff computers. The difference also in SIPA is that it applies to different age groups. So 17-year-olds are considered minors under Michigan law and not under SIPA. So if you have to comply with both SIPA and PA 212, your internet policy should have a different provision for addressing 17-year-olds. So to filter or not to filter, what does the Supreme Court say about the legality of SIPA? Again, I know I put this information so that you can see it in there. The end result was that the Supreme Court said that SIPA was not illegal and that it was not a violation of federal law to condition the receipt of federal funding on these particular conditions. The main issue with that allowed the court to find this was that if a patron comes up, if you are complying with SIPA, and this should be addressed in your policy, if you are complying with SIPA or required to comply with SIPA, you have to have the ability to unblock the computer terminals for what they call bona fide research. And bona fide research is not defined under the SIPA. It's going to be something that the library will have to determine when a specific request is made. I think it's very frustrating to libraries that they're not given more detail on that or more guidance, but that's the nature of the law. Again, certain speech such as child pornography and obscene speech is not protected by the First Amendment. So your internet use policy should specifically prohibit pornography and obscenity. Again, one of the toughest things that we deal with is whether something is obscene. And I've put into the slides here what means to be obscene. And again, it's going to depend on community standards, but I will tell you, it's very difficult to meet the standard of obscenity. And most of the stuff that we see in libraries is likely not going to reach that standard. But again, the purpose of the session is to talk about policies. Your internet policy should address obscenity and should prohibit obscenity. And then it may be a specific fact-based legal issue that you have to deal with at the time to determine whether a particular complaint or whether somebody was looking at falls within the definition of obscenity versus pornography. again, Michigan law and federal law prohibit child pornography. There was a time where we were having, and unfortunately, a number of child pornography issues in libraries, and I haven't seen it as much lately, so I'm going to knock on wood here that that is becoming less of a problem, and generally, and less of a problem for public libraries. But again, child pornography should be taken very seriously. If there's an allegation of child pornography in the libraries, there should be an immediate call to your lawyer to address how to handle it and how to handle it with the police. Pornography is not obscenity, it's something less than obscenity. Courts have upheld a patron's right to look at pornography as protected by the First Amendment, and this includes a right to look at pornography in the libraries. This puts you in a very difficult position, I think, at times with your community, because you have taxpayers that have kids that come into the library, and they are very upset if their kids are have look at or have potential, run-ins with people who are looking at pornography. We struggle with that because there's the First Amendment rights of the patron who's looking at the material, and then there's the rights of your patrons who want to come to the library and not have to be subjected to that material. But again, that's something that when it's more of an enforcement issue than a policy issue, because you simply will have a problem if your policy says no, you can't look at pornography, because that may be a violation of someone's First Amendment rights. So keep that in mind when you're talking about internet use. So we've dealt with the real meat of the internet use policy, which is how do you deal with compliance with Michigan and federal law. Then there's a lot of other information that should be in your internet use policy that just is generally how you operate your library. Can the terminals be reserved? Do the patrons have to pay for copies or printouts? May more than one patron work at a terminal? Is it first come, first serve? We say no violation of copyrights, no illegal use of the policy. So a lot of there's more sort of content neutral issues that have to be addressed. But one of the things you really want to make sure is that you are equally enforcing the policy, and that, again, we talk about time, place, and manner restrictions. So it's a very easy call to say, no patron may use the terminal more than 2 hours per day. That's time, place, and manner. If they're doing homework for 2 hours, if they're looking at Facebook for 2 hours, it shouldn't matter. You have to make sure you continually and evenly enforce these policies. So for example, if you've got a patron who's looking at Facebook for 2 hours, and next to them you've got a patron who's looking at pornography for 2 hours, and you let the patron who's looking for Facebook go on and sit there for 3 or 4 hours, but make the patron who is looking at pornography turn off the computer after 2 hours, there could be an allegation that you're trying to regulate the substance of what they're looking and not the time, place, and manner. So just be very careful to have neutral enforcement of your policies, so that you can't be accused of enforcing the policies for a substantive reason, or the fact that you don't like the content of that particular person's speech. Privacy policies. Privacy policy should address library records as defined by the Michigan Library Privacy Act, and I put the definition of a library record in here. It personally identifies a patron, including the patron's name, address, and telephone number, or that identifies a patron as having requested and obtained specific material from the library. So I think it's a false statement to say that only, releasing the titles of what someone's looking at is a violation of law. Giving the patron's name, address, and telephone number is specifically a violation of the Michigan Library Privacy Act. So if someone comes to your library, let's say they get in a fist fight with another patron in the library, and they check out a book on the way out through the automatic scanners, you can't go into that record, figure out who they are, get their name and address, and hand that over to the police without having a court order to do so. That would be a likely violation of the Library Privacy Act. So you have to be very careful. The other issue that I think is still in some debate among libraries is the surveillance tapes. My personal position is that surveillance tapes identify the person because they're like a mugshot. They visually identify who that particular person is and the fact that they're using the library. So I do include those in the definition of a library record. So internet history, surveillance tapes, circulation records, and other documents, these are all things that should be considered when you talk about your privacy, and taken into account with your privacy policies. You can, in the privacy policies, we treat different classes of records differently. So for example, FOIA requests, those should be handled through the FOIA coordinator and according to your FOIA policies, but anything that's a library record is, as defined in that previous slide, is specifically exempt from disclosure under the Freedom of Information Act request. So those requests can be denied through the FOIA process. State and local enforcement records and federal records, federal subpoenas, those are a little bit different. If you get a search warrant or a court order from any type of law enforcement agency, the policy typically requires the director to, work with the president or work with the lawyer in order to address those types of requests. I haven't seen as much of that lately, and typically, as a matter of practice, we're able to work with the law enforcement agency to address their needs with the subpoena. But again, it's important to keep in mind that that the library holds many records that are going to be exempt from disclosure by statute, or potentially revealing the content of what people are reading. So those should be dealt with carefully and make sure that they're only given out pursuant to specific process, either by a FOIA request or with a court order as required under Michigan law. Minors are it's very important to keep in mind that minors, the way that they're viewed under the law is that they really don't have very many different rights with respect to how the library views them. The library is not like a school acting on behalf of the parent. So there's a whole argument that minor patrons have the same right of access to a library as an adult would. So you have to be very careful. The Library Privacy Act specifically says that a person can have access to another person's records if they agree to be responsible for the payment or return of those materials. This can apply to adults. So, basically your library privacy policy should address the fact that you're only going to give out records to that person or a person that has agreed to be responsible for payment or return of those materials. So I think it's very easy to believe that there's no violation if you have a minor child and you tell them the name of the book they're reading. And I think if you think about it in this context, if it's a 5-year-old and they've checked out a Dr. Seuss book and it's likely the parent was with them when they checked it out, you may think, well, what harm can come of that? And it's not really that big of a deal. It's their parent and they have the right of access. But when you talk about minors under Michigan law, it could be a 16 or a 17-year-old, and maybe they are, going through a difficult time and are checking out books on very sensitive topics that would be very troubling maybe to their parents, or that they wouldn't want their parents to know about. So you have to think about those types of situations when you're dealing with your privacy policies and enforcement of those policies. For a court order, understand the library has the right to hearing before turning over library records. I've been practicing library law for almost 20 years now, and I've actually never been to one of those hearings. They don't happen that often, but I do want to point that out if you are trying to challenge a court order or some type of legal process, that you do have the right of a hearing before turning over those records. The other one is a media policy. This is very important to have when you have a crisis situation. You want to make sure, especially because you are governed by a public board that consists of 5 to 8 typically individual members, and those members may not have all the same opinion on something. You want to make sure that it's a library's policy that it addresses who the spokesperson is and who's the one that can speak for the library, so you don't have inconsistent messages being conveyed about the library or about an event. This is especially important to make sure that that person has a strong understanding of the Library Privacy Act and what may be given out, because you don't want someone to inadvertently violate the Library Privacy Act through a statement to the press. we had a patron once that was ended up suing a library over the enforcement of a patron behavior policy. This patron was suspended, and one of the counts in the circuit court case was defamation, and the count involved the library, accusation that the library revealed the name of this particular patron to the press and caused embarrassment and what have you. Now, it turns out in that particular situation that the library had never released the information. In fact, it was that person who went to the press himself to complain about the library. But again, you can see where you don't want to find yourself in that situation where you're dealing with a lawsuit that involves Library Privacy Act or any sort of defamation claim. Any media policy should regulate taking pictures inside the library by the media. Sometimes when it happens in a crisis, if there's pornography or child pornography discovered at the library, they want those background pictures for their piece of people like working at the computers and so forth. So you just want to make sure that you have a specific written policy in place that protects the library from being able to exclude those people from coming in and just filming patrons. But be careful about the Open Meetings Act, because any prohibition against videotaping or audio taping inside a library should not apply during an open meetings, because in the Open Meetings Act specifically allows you to do that. FOIA policy. The Freedom of Information Act was amended in July of 2015. If you have not updated your policy before then, you need to immediately do that, because it's required by the law, and it affects whether you can charge fees for FOIA requests. If you don't have a written policy, in summary, you're in violation of law and you're not able to charge fees. This would be very unfortunate if you get a very large FOIA policy that takes up considerable amount of, or FOIA request that takes up a considerable amount of time. Again, once adopted, you put your policy and the written summary on the website, because otherwise you have to include it in every written response. If you have it on the website, you can just put a link in again, but your FOIA policy should be in compliance with the new Michigan law. They tend to be long. There's a lot of regulations in the law. You want to make sure your I's are dotted and your T's are crossed, but FOIA policy is required by law. Record retention policy. There's a couple more slides left. These are sort of the bonus policies, and I will take the time, and we have a couple minutes left, and I will go through as many as I can, but there's a list at the end of just general policies to think about and may be applicable to your particular library. There is a state-approved library policy on the website. This has been approved by the state of Michigan, and all libraries, if they don't have a specific record retention policy in place, should be using this policy. Typically, we actually have a small policy that adopts the state standard policy as the library's own policy. If you want to deviate from that policy, from that state-approved policy, you have to get state approval. So a library, and this is not just libraries, but any other public entity in Michigan, cannot just decide what its own record retention policy should be. It has to comply with either the mandated state, this mandated state form, or you can adopt your own form, but that form has to be approved by the state of Michigan, and there's a whole approval process to go in there. It's very important to have to stick with your record retention policy and comply with it, because frankly, a lot of libraries don't do as much purging as they should, and this may be a space problem, a record retention problem. It'll certainly become a problem if you get a FOIA request asking for certain records. But it's also important, equally important for you to understand as a library what records you must be keeping permanently, because there's a whole class of records that you should never be purging or getting rid of, including meeting minutes and other types of similar documents. So be very careful about that. Circulation policy. I've been doing a lot more circulation policies lately than I had in the first part of working with libraries. I think it's very important that the policy clearly identify who qualifies for service and what type of documentation is required for a library card. For example, if you have different classes of library card, it should be specifically set out in your circulation policy of if you have you know, if you are a resident of the district, for example, you may have access to all library services. If you are a non-resident card, you may have restricted services, and that should all be spelled out in writing in your circulation policy. And it should also obviously talk about circulation periods and what fees may be charged. Again, material selection policy, challenging and reconsidering books, programming, or other materials. This is one that's very important. I don't know that it's used as much as say, a patron behavior policy, but when you need it, you need it. I mean, if a patron comes up and complains about it, it's more, lately I've seen just anecdotally, it's more programming than books, programming and sponsorships, I would say, than books. And so you want to make sure your material selection policy isn't just limited to challenging the written, you know, CDs, video, whatever you have in your library, but would also address your library's decisions with respect to programming. Again, having those written processes in place is going to help you. You don't want to get this in place after you've had an incident or after you've had someone challenge one of your programming. This is a proactive thing that should be in place at this point. Bulletin board and display policy. Again, request to use a bulletin board or display space. This is where I see a lot of issues with people wanting to limit or address groups. You know, can we prevent a church from putting a bulletin up on our bulletin board? You cannot, again, deny someone the same right as you would allow another group simply because of who they are. For example, if a nonprofit is allowed to post a 8.5 by 11 sheet of paper notifying the community of a bake sale, you cannot prohibit a church from doing that because they're a religious institution. So again, it should be content neutral, time, place, and manner. You know, you can say it's limited to, you know, one, for example, 8.5 by 11 sheets of paper, one piece of paper per group. Things that are not, would apply to everybody, but that would help regulate your bulletin board space. So there's bulletin board space, there's also display space. Your library may have a bulletin board and display, or one or the other, but if you allow groups to come in, and if you have cabinets, for example, that have you know, displays, and people can come in, and you know, I've just walked in on one that had a big Lego display, and some community family had donated some Legos to put on display. Those are the types of things that should also be addressed in that policy. But you have to consider Michigan law. For example, don't allow unattended petitions. Petitions must be witnessed by law. So you want to make sure that your bulletin board and display policy prohibits anything that would be prohibited by law. And again, we've kind of already discussed what these time, place, and manner restrictions might be. So the rest of the slide presentation are lists of common policies that we have. Some of them have been covered, some of them haven't been covered. So these are kind of a checklist to see if your library has these policies or may be interested in developing these types of policies. I've run over by about 3 minutes, so I really appreciate you sticking with me on what is a long session. And if you have any questions, please feel free to either call me, email me, or whatever, and hopefully we can find an answer. Thank you again for your attendance. We really appreciate it. Did I screw it up? Is it still online? I feel like it's still online.